Good day. Our topic for discussion today is about the powers of the Secretary of Labor. Now, just like any governmental agency, the executive department headed by the president is the one that executes the law. Now, insofar as for example, criminal statutes are concerned, it is the Department of Justice that enforces it. Insofar as tax measures are concerned, it is the Department of Finance that executes tax measures. Now, when it comes to labor legislations or labor laws, it is the Department of Labor that is primarily in charge of executing it. And under the principle of the alter ego doctrine, the president who cannot physically perform all of these functions designates a cabinet secretary to execute this particular measure or measures. And here, the Secretary of the Department of Labor and Employment is the one that is in charge in executing labor statutes or labor laws. If and when the Secretary of Labor does this, he or she does it under the office of the president and by authority of the president. So it's as if it is the president of the republic executing it. Now, please note that the powers of the Secretary of Labor is generally capsulized into two. You have what we call as enforcement powers, and on the other hand, you have what we call as visitorial powers when it comes to labor standards. As you well know, the Constitution is very clear on the state policy towards labor, which is affording full protection to labor. And to afford full protection to labor, local and overseas, the agency concerned must be possessed with enough powers and prerogatives to ensure that labor standards or even any labor laws will be enforced. And this is where the so-called enforcement and visitorial powers come into play. Now, the powers of the Secretary of Labor under the Labor Code have been actually strengthened over time, and the Public Act 7730 have, or rather, has expanded these powers of the Secretary of Labor. Because in the past, there were so many restrictions as to what the Secretary of Labor can do. For instance, in the past, if the amount is only 5,000 pesos, that is the range by which the Secretary of Labor can enforce labor standards. Over and above 5,000 pesos, it will have to be referred to the National Labor Relations, which is an adjunct agency from the Department of Labor. It's not under, it's independent, but it's connected in a way for administrative process, but it remains as an independent quasi-judicial body. And as you well know, in the Philippines, when cases are to be heard, it takes a while, and often it takes forever for parties to be able to attain the justice that they want. And in one of the related discussions we had with respect to the jurisdiction of the Supreme Court, this is also one reason why the Supreme Court, uh, in the Eternal Gardens case, opted to refer cases to the Court of Appeals instead of it deciding labor cases because of the length of time that labor cases are resolved. Now, what is this visitorial and enforcement power? Now, if we take a look at the definition of each one, these two are different. When it comes to visitorial power, um, this is actually one of the extraordinary powers that the Secretary of Labor can do or the President can do. Why? Because if you look at the Bill of Rights under the Constitution, with respect to uh, search or seizure, the Constitution requires that search and seizures may only be effected through a search warrant, no? That a court of competent jurisdiction may issue. If there is no search warrant, unless there is waiver as a rule, nobody can just enter uh, into anybody's place and then request for inspections and all that. No? The right to be secured in the home is a constitutional guarantee. Now, you may say that a home is different from a workplace, but you see, a workplace uh, should enjoy a certain degree of privacy also. As an employer, theoretically, an employer is akin to a property owner, and your right to property is so constitutionally protected. Nobody can just take away your property without due process of law. Following this argument, then theoretically, even with respect to your workplace, you have to enjoy that sense of privacy. And you employers do so enjoy. However, with respect to these visitorial powers, this is more of an exception. And again, this is the philosophy behind this principle is the fact that, again, repeatedly, as we always stress, labor laws are vested with public interest. So the terms and conditions cannot just be left between the parties, but as a rule, the relationship can also be determined by law. And whenever the terms and conditions are way below what the law provides, and that agreement, even if so voluntarily agreed upon, can be set aside. Under this principle, the state is a stakeholder in every labor issue. So it's always a tripartite relationship between and among the workers, the employers, and the state. So the state has to protect the people. And as we said, no, those who have less in life should have more in law. On this principle, visitorial power gives the Secretary of Labor and Employment or his or her duly authorized representative, including labor regulation officers or industrial safety engineers, to have access to employers' records and premises at any time of the day or night, whenever work is being undertaken, and the right to copy from, to question any employee, and to investigate any fact, condition, or matter relevant to the enforcement of any provision of the labor code, or even wage order or rules and regulations issued pursuant thereto. So clearly, when it comes to matters pertaining to labor laws and regulation, and whenever there is work, you cannot just prevent the Secretary of Labor or his or her representative to investigate, to inquire, and even to secure copies. Now, this is a right that is given to the state for the best protection of the people. Why is this? What's the philosophy behind this other than what I've mentioned? Of course, it is through the investigation and to the verification of records where the Department of Labor will be able to see if there are violations, and there should, and rectifications that has to be done. So this is very important. Otherwise, uh, if you will not allow the Secretary of Labor to exercise visitorial power, then there is no way, or there would be difficulty for the Department of Labor to monitor violations of labor standard laws. So this is why this is important. So as you see, uh, they do not need warrants or search warrants. No? Now, when visitorial powers is therefore exercised, it is always prudent or most prudent for the employers to make sure that they will um, entertain inquiries. In fact, you don't fight them. You cooperate with them because they will also help you uh, correct whatever policies have been made that is not actually sound. So this is why this is an important authority given to the Secretary of Labor. Now, the other power, which is the enforcement power, on the other hand, um, provides that the Secretary of Labor, or even through the regional offices, you see, the Secretary of Labor um, uh, is the main cabinet authority, and under the Secretary of Labor, there are regional uh, directors, no, that acts also in behalf of the secretary. So these regional directors, whenever there is an employer-employee relationship, can order and administer, no. But this is important after due notice and hearing, compliance with labor standards. So the proceedings are generally summary, and if there is a finding that there has to be uh, rules and regulations that must be complied with up after inspection or the exercise of visitorial power, they can order that. And if there is failure to meet this um, this orders, the Secretary of Labor, through the regional director, can order the execution of these orders. Except, of course, if it is filed, no? Cases resolved by the regional director, although this will be covered by labor relations, may be appealed to the Secretary of Labor. So the Secretary of Labor can actually review the decisions of the regional directors. No? Um, And if it finds that the decision is not based on law or rules, then it can set aside the orders of the regional director. So take note of these two very important powers and functions of the Secretary of Labor, which is both a duty and a right on its part for the best interest of the workers. Now, please take note of this. Under the Labor Code as amended by RA 7730, the DOLE now is fully empowered to make a determination of employer-employee relationship, but only in the exercise of the visitorial and enforcement power. Now, this is a very ticklish issue because generally, employer-employee relationship is within the jurisdiction of the labor arbiter under the National Labor Relations Commission or the NLRC. And in the past, the Secretary of Labor does not have that power to determine employer-employee relationship. However, in the light of the expansion of RA 7730, the amended rules grants the Secretary of Labor such right or powers to determine employer-employee relationship, but only for purposes of the enforcement and visitorial powers. Now, this is also important. Why? Because in the past, because of the concept of this labor-only contracting, yung mga concept of agencies, the agencies proliferated, no? The practice of engaging workers in the guise of an agency has proliferated. In fact, not only small industries, no, even big companies, even big networks, no, they claim that we're not employees of the network, we're employees of the agency, and the agency assigns us to the network, etc. So there has been some form of abuses. Why? Because if this is the arrangement, what happens is that the right to security of tenure is undermined. So for example, you go to, and this is what I ask you to do, no? If you have the chance to go to small restaurants and even big restaurants, you can ask them, who is your employer? Now, they may say that, agency, we're employed by an agency. But, theoretically, that is highly questionable. Why? Because if the work that is assigned to you is directly related to the business, that cannot be hired to an agency. An agency may only be engaged for work that is not directly related to the business. And because of the proliferation of this practice, what happens is the security of tenure is undermined because the company need not hire you permanently because you're under an agency. You can be permanently hired by the agency. That has been an issue, and it's not good. That is why in the process now, with the power given to the Secretary of Labor, they can now make such determination. And often, when they find that one is engaged in labor-only contracting, which is like just hiring an agency, they will order the employer to absorb these employees as regular, because that is in the context of enforcing a labor um, standard. So of course, you can always appeal that to the Secretary of Labor and later on to the Court of Appeals. But the point is, for an expeditious resolution of similar situations, the Secretary of Labor can now do that. No? Now, aside from that, uh, please take note that before, no, if the amount involved exceeds 5,000 pesos, the jurisdiction is the labor arbiter. Now, but with the amendment of this power of the Secretary of Labor. RA 7730 now allows the Secretary of Labor to execute and enforce money claims even beyond 5,000 pesos as long as it is um, prompted through an inspection by the DOLE. So as long as it's related to the visitorial power, even if the amount goes up to millions, yung hindi nababayaran, it can execute. And if workers fails to address it, then the consequences may truly be harsh. Now, uh, to recapitulate, if a complaint is brought before the Department of Labor to give effect to labor standards or other labor relationship, and there is a finding by the DOLE that there is an existing employer-employee relationship, the DOLE exercises jurisdiction. Now, but however, if the DOLE finds that there is no employer-employee relationship, then you can go to the NLRC and file. Now, if the amount that needs to be executed is definitely more, then you have to abide by it. That has to be addressed. Otherwise, it's going to be a potential problem. Now, if however you want to question the employer-employee relationship, as I said, if there is a finding by DOLE that there is one, you can appeal to the Secretary of Labor and later to the Court of Appeals. But there is no finding of employer-employee relationship, then you go to the labor arbiter if you are the employee. Now, I invite your attention to these two cases of Guico versus Kisumbing and Batong Buhay Gold Mines versus De La Serna, because in these two cases, the Supreme Court emphatically stressed that the Secretary of Labor does have power to execute these huge amounts. In one of these cases, this was just a Xerox company that did not comply with the minimum labor standards. Now, in hindsight, what if this Xerox company registered itself as a BMBE or a micro business enterprise? Then that would not have been an issue. But the problem is it was not registered. So it was found liable to pay, I think, less than 10 employees or so back wages. I mean, the unpaid wages. So it amounted to millions. And the determination of liability amounting to millions was only made through an inspection. So, unfortunately, they were invoking that it is the NLRC who should have jurisdiction because the amount is more than 5,000. But then again, because of the amendment, which was a misjudgment probably on the part of those who assisted the the proprietor legally, they did not see that. So because they did not see that, the remedy should have been an appeal to the Secretary of Labor by posting a bond. There was a failure to post the required bond and all that. So the decision had to be enforced. So that is the danger of simply ignoring the visitorial power of the Secretary of Labor. It can amount to millions of losses. So if and when you become businessmen or you work for a company, do not ignore these visitorial and enforcement powers, because if you do so, it's more difficult to to get a reprieve because you need to file an appeal, you have to post a bond. It's more difficult really, and it can result into a lot of losses. So take note of these powers of the Secretary of Labor. And again, I invite you to read the cases of Guico versus Batong Buhay Gold Mines for better understanding of the powers of the Secretary of Labor and Employment. Now, aside from these powers, let me just tell you that in the course of the functions of the Secretary of Labor, the office also usually issues labor advisory. But of course, these labor advisories are mere guidelines, but they can be a basis of enforcements of rights. So I also invite your attention to the website of the Department of Labor and Employment, where they provide a summary of all of these guidelines. And if you end up working in the human resources department of a company, this would really truly be of help. You know, understanding the powers and prerogatives of the Secretary of Labor would be a big help. And with the advent of information technology, these rules are just at the fingertips, at your fingertips, and you can easily access them online. Thank you very much. That wraps up our discussion on the powers and prerogatives of the Secretary of Labor and Employment. Thank you very much.